Hello everyone, I welcome you back to our channel. This is Legal Mindset at the Bar, and today we are going in for Tort Law 2, and we are going to see a case that changed the law of negligence. We are going to see the case of Donoghue versus Stevenson, a case reported in 1932. So I urge you to subscribe such that we continue and dive into our topic today. Okay, what should you know about the case of Donoghue versus Stevenson? I urge you to hang on until the end of this video, where I shall take you through the fundamental legal principles governing the law of negligence. So, in the case of Donoghue versus Stevenson, the appellant, Mrs. May Donoghue, drank a bottle of ginger beer manufactured by the respondent, who was Stevenson. So, the bottle of ginger beer had in it decomposed remains of a snail. So, before we go to the principles, allow me to give you a background, the facts of the case of Donoghue versus Stevenson. Now, in August 1928, May Donoghue and a friend went to Well-Meadow Cafe in Paisley. When they reached the cafe, they ordered for ginger beer. After ordering, the ginger beer was delivered in an opaque bottle. Opaque, I mean the bottle was not transparent. The glass in which the bottle was made was an opaque material. It was not transparent. So, she was given a side glass where she could pour and drink. But, however, you should know that it is not May Donoghue who paid for the bottle of ginger beer. It is a friend who paid for her. It is a friend who bought for her. When she poured the first sip, she drank half of the bottle, and on pouring the remaining half into the glass, decomposed remains of a snail floated on top. So, she got fear. She got intestinal disorders, and this transaction did not only affect May Donoghue and the manufacturer Stevenson, Well-Meadow Cafe, but the transaction and its aftermath formed the basis of one of the most important Scottish cases in the world legal history. It laid down a number of principles that are sounding in many halls of justice even up to now. It changed the fundamental legal principles of the law of negligence, because before 1932, the law of negligence was very clear that the person who wanted to sue under the law of negligence could show a contractual obligation to someone they are suing. You should show that there was a contract, a direct contract between me and the defendant. So, this case has a number of principles we are going to see, we are going to lay down in our issues. Because May Donoghue, in the court of first instance, was not favored. But however, when she appealed to the House of Lords, the House of Lords changed everything. It changed the position of the law of negligence as it was before 1932. Lord Atkin changed everything, and we are going to see some of the issues which we shall rotate around in our discussion. So, the first issue we shall use whether the manufacturer was liable for breach of his duty of care towards the consumer. That is the principle of negligence. The second one we shall see whether the plaintiff can directly sue the manufacturer even if the bottle was not purchased by her. That is the contractual liability and the neighbor principle. Now, to dive into it, we are going to first look at the position of the case on negligence, our first issue. So, on that, the House of Lords ruled and affirmed that negligence is a tort. So, it said that the plaintiff can take a civil action against a respondent, whose negligent acts cause the plaintiff harm or loss of property. Because previously the plaintiff had to demonstrate some contractual arrangements to sue under the law of negligence. But here in the House of Lords, Lord Atkin's judgment established that Stevenson was still responsible for the integrity of his property, his product. Mark my words very clearly. Lord Atkins said Stevenson was still responsible for the integrity of his product. What does that mean? If you do a negligent act, you are a manufacturer and your final consumer gets harm, it means you are responsible for the integrity of your product, even though there was no direct contractual obligation. Now, let us now move on to the duty of care. The duty of care, the House of Lords established that the manufacturer has a duty of care to the end consumers, all users of their final products. So, in his ratio decidendi, Lord Atkins stated that a manufacturer of products which he sells to reach to the ultimate consumer in a form in which they left him, you get, owes a duty of care to that consumer and has to take reasonable care such that that consumer does not get any damage as a result of their product. So the principle evolved and now it forms the basis of the product consumers it forms the basis of laws that protect consumers from getting harm from contaminated goods. So that is the duty of care. A manufacturer owes a duty of care to their final consumers. Now, let us go to the neighbor principle. On the neighbor principle, Lord Atkins stated that you must take reasonable care to avoid acts or omissions which you can reasonably foresee, which would likely to injure your consumer, your neighbor. And interestingly, you are asking who is a neighbor in law. Lord Atkins asked himself that question too. He asked, then in law, who is a neighbor? Who is my neighbor? He answered it. He stated that the answer seems to be a person who are so closely and directly affected by my act, and I ought to have them in my mind when I am considering the acts I do and the omissions I do. Get it very clearly. Your neighbor-in-law is that person who can be affected by your acts. So you should put them in mind that if I do this, my neighbor will be affected. That is it. So, in the bottom line of this case, Donoghue versus Stevenson, the case produced Lord Atkins' controversial neighbor principle, which extended the tort of negligence beyond the tortfeasor and the immediate party. The tortfeasor is the person who does the tort, and the immediate party, the immediately affected party, the contractual obligation between the parties. Does not mean that if I buy a product and I give it to my friend, she cannot sue, he cannot sue. No, because they are the neighbor. They are the consumer of your product. which Lord Atkins said that you have, like, you are still bound for the integrity of your product. You are still liable, because in Donghue's case, she had purchased the ginger beer, but uh, but had not received uh, but she had received it as a gift. So she was a neighbor rather than a contractual party. In conclusion, a manufacturer owes a duty of care to their final consumer. There need not to be a contractual relationship or privity for a final consumer to sue the manufacturer, to sue for negligence. The case of Donoghue versus Stevenson changed the law of negligence prior to 1932, which said that you should show a contractual obligation. This is Legal Mindset at the bar. I urge you to subscribe such that we move together. If you find this information helpful, share with your colleagues.